Mr. Carruthers, you are charged with driving while intoxicated. You're facing up to 6 months.
Right from the start. This is serious. A DWI in Texas might sound minor, but even a first-time charge can wreck your record. And watch closely. The judge isn't just reading rights. He's setting the tone for a possible storm ahead.
In jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot.
He didn't just get caught drunk. He hit someone. This instantly elevates the case from a routine DUI to something much darker. When bodily harm enters the picture, judges start thinking about public safety, not leniency.
Afford one. One will be appointed to you, sir. Okay.
Wait, what? He hits a cyclist, then assaults the victim? That's not just reckless. That's a legal disaster. At this point, prosecutors could tack on aggravated assault, hit and run, and intoxication-related enhancements. The judge's disbelief here is absolutely justified.
On March 2nd, 2024, officers were dispatched regarding a major crash in Harris County, Texas. Upon arrival, the officers made contact with the wheel witness. The witness observed the defendant's 2005 gold Chevy strike an unknown person riding a bike with his vehicle.
Whoa.
Bike, yes, Your Honor.
Struck a person?
Riding a bike, yes, Your Honor.
Okay.
The defendant then got out of his vehicle and began assaulting the unknown person and then drove away from the scene.
Whoa. You're telling me he strikes someone in a car and then on top of it starts assaulting this person?
Yes, Your Honor. The unknown person fled the scene, and the defendant was promptly found by officers 1 block away in a private driveway. That was not the defendant's residence. Upon contact with the defendant, the officer observed an odor of an alcoholic beverage, slurred speech, and poor balance. The defendant was detained. He refused SFSTs. The DIC was read. The defendant refused to provide a specimen. A blood search warrant was signed and executed. He was identified by his Texas driver's license.
I had just so many problems with this.
So, Judge, we have been unable to locate the unknown person that was on the bicycle. He fled because he was getting assaulted. We have no way of finding him.
Not only that, how do I know he's not consuming anything after the fact? How do we know he doesn't go home and chug a fifth of vodka?
The DIMS does say he was promptly found by the officers 1 block away.
I get it. I get it.
This moment hits hard. The judge isn't being dramatic, he's pleading. After hearing about so many violent DWI cases, this is the raw frustration of someone who's seen too many preventable tragedies. That line, "Please don't kill someone," says everything.
Promptly is a conclusory word.
I'm pulling up the OR right now, Judge, to see if they have anything more specific.
Can I say something now? Don't, Mr. Carruthers. Don't. Are you losing? Are you losing?
No.
Then stop. Anything else? Was that it?
Looking at times, Your Honor, to see if we can establish when he was found based on when he was dispatched. I don't think we have anything additional, Your Honor.
It says, yeah.
Mr. Carruthers, I'm going to find no probable cause on your case. You know, we have enough death. We have enough dismemberment. We have enough blood all over our streets. Please don't add to it. Please just don't kill someone. That's all I'm asking you to do, man. You know, $40, an Uber will take you anywhere you want to go in this county. Anywhere. Please, don't kill someone. Take a seat, please. Hi.
Well, I have 2 clients I need to post for. The first one is Gallegos. So he did do his drug test, but it's today. He did come positive.
For
the THC, but I wanted to see if we can allow the actual results coming back from the labs, because my client was.
A $10,000 bond for a misdemeanor? That's steep, and judges usually notice. It suggests something in this defendant's background or prior behavior has the court on edge. The defense asking for a reduction here could go either way.
Quite surprised about
Okay, so we'll put it off 3 days, 4 days.
5 days.
Yeah, it takes about 5 to 7 days depending
Okay,
on how.
we'll set it off a week. It's okay.
And then my other client, Your Honor, is Mr. Mando.
What's the last name?
Mando
Is that,
Fernandez.
okay.
I'm going to address the bond that's set at 10,000 right now.
Page 32, Judge.
Yeah, thanks.
Judge, do you want to allow? Without addressing it?
Yeah, yeah, because I don't know anything about it.
Okay.
Yeah.
Yeah, no, Fernandez.
And hold on, oh, and let me just do this real quick, this arraignment. While they're bringing him out, I'm gonna do an arraignment. All right. Are you Mr. Fernandez?
Yes, sir.
Morning, Mr. Fernandez.
Morning.
Sir, you're charged with terroristic threat of a family or a household member. You are facing up to a year in jail and or a $4,000 fine. The reason you're out now is your bond is set at $10,000, which is unusually high for a misdemeanor. I don't know why, but she's asking for a bond reduction. I'd like to know what happened in the case and we'll go from there. Okay.
On March 5th, 2025, an officer was dispatched to a family disturbance type call at a residence in Harris County, Texas. Upon arrival, the officer made contact with the defendant. And the complainant, the defendant's mother, was trying to make him leave the house because she felt like her life was in danger due to his behaviors and threats he made to kill her with a gun. The complainant provided text message from the defendant's therapist. The defendant also told his brothers about the threats. The defendant showed his 14-year-old brother pictures of guns and stated all of his friends have guns. The brother felt in danger. The defendant admitted he made multiple threats in the past of killing his mother with a gun.
So,
Did I hear a specific threat?
Not directly to the mother, but he had threatened to kill the mom to other people in
Okay,
the
but
family.
that's not, but a terroristic threat has to be aimed to a specific person and there
Yes.
has to be immediacy.
And my response to that would be that it was aimed towards the mother, threats to kill with guns while showing pictures of guns that his friends have access to shows immediacy. And to show intent to put her in fear would be a question for the jury of whether he intended to make her feel fear, whether or not it was directly to her or to others.
so I,
Where the threat is.
So, I mean, so he told his brothers that he was going to kill his mother.
And
That is what the complainant stated. I don't have a time. Wait. As per mother, the last time the defendant had made those threats was 2 days ago. So on March 3rd.
that's not even.
no, this has to be, it's something where, I'm going to kill you MF now. It's not, hey man, I'm going to do this in a couple of days, when I get up to it, because I'm kind of lazy. I got shit I need to do. It don't work like that.
I understand. I'm just concerned, so.
Gotta be careful. You got but one life. How was jail? Sucks, right?
Yeah.
I mean, we're not asking for much. All the knuckleheads that have guns that run in the street, they're going to end up in here one day. That's all. I tell you, go start asking anybody when you get back to the tank, Really, life is too short to live in a box like this. You don't need a gun. How old are you?
Just turned 18 on March 5th.
You don't need a gun. Get your ass back into school, man. Knowledge is power. You want to make some money? Learn something. She's amazing. Look at her. How much money you make? Don't answer that. She makes a crap load of money because she knows things.
Yeah.
That's what life's about. Fancy vacation, nice cars, these big ass beaches, blue water. That's what life's about. But you get it in school by gaining knowledge, not with a gun, right?
Mm-hmm.
I'm going to find no probable cause. Do something, man.
Sure.
Get back into school, learn something.
He's in school, so he needs to finish school.
Yeah.
Hey,
he's gonna do.
you're gonna get out today. Be somebody.
Yes, sir.
You're not a statistic. All right.
Thank you, Your Honor.
Good morning, Judge. I got appointed this morning to Mr. Butler, first name Philander. And Your Honor, he has a pending felony case. However, I did see that he made bond on that one, and this is the only thing that's keeping him in custody right now.
What would you like?
Your Honor, and realistically, I talked to him to see if there's any means for his family or friends to go ahead and pay this bond, which I ultimately would be around 100. He didn't provide any information on that. He's actually not sure how he made bond on his felony case.
He got a PR bond on the, so it looks like he picked up a UUMV, February 24th. And now he's picked up a misdemeanor theft. I guess they haven't gone back or looked. I don't know what they're going to do. He's set for 331 on that case. I don't know if they're going to yank the bond on that or not. I don't know. But he wants me to give him a PR bond.
Yes, Your Honor. I do have contact information. I have an address for him as well.
Hey, Deputy Miranda, do you mind bringing up Mr. Butler? Yeah. Give me a second. Let me do an arraignment real quick and then we'll talk to Mr. Butler. Good morning, Mr. Butler. How's jail?
Not good.
Great. That makes me happy because the harder time you have, hopefully the more you have them for a reason. Here's the rub. Your lawyer is asking for me to give you a PR bond in this case.
That's it.
You were on bond for an unauthorized use of a motor vehicle,
That's it.
and now you've picked up a theft case. I have no idea what happened on that theft case. We're going to figure out what happened real quick, and then we'll talk about your bond.
That's it.
You have the right to remain silent. Anything you say can or will be used against you. You're facing a Class B theft, so it's up to 6 months in jail and or a $2,000 fine.
On March 7, 2025, an officer was dispatched to a theft call at a Target in Harris County, Texas. The defendant was observed on surveillance video placing merchandise in a black suitcase he also obtained from the business and crossed all points of sale without attempting to pay. The defendant was detained without incident. The total value of items stolen was $355.46.
So you said he also has a lot of
No, that was Mr. Phillips.
Mr. Phillips has that account.
Yes.
Miss Keela Lee?
How old is Mr. Butler?
He's 25 years old, Your Honor.
Miss Keela Lee?
Miss Lee?
Judge, I was looking, I did not see any sort of history of him not showing up for court or any sort of bond forfeitures on his previous cases.
The problem is you keep picking stuff up. Stop. I don't want you to say, but my problem are two things. Number one, sometimes people are their own worst enemies and they continue to pick cases up that they're just, it can't stop. I don't know. But you, Mr. Butler, you're 25 and you have now 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Now you're on your 13th and 14th case. And a lot of these are very serious felony cases. Unauthorized use, robbery, unauthorized use, felony fraud.
The judge's patience has officially run out. For arrests in 2 months, that's a flashing red light for repeat offender behavior. He's not being harsh, he's protecting the system from a revolving door of crime. But you can feel the disappointment in his tone.
Evading in a motor vehicle, felony theft. Now another unlawful. Why? Why would we continue to give you PR bonds when since January, you're on your 4th case? Why?
Soros.
The thing that you need to consider, Mr. Butler, is it would only cost literally $100 to get you out of jail right now. And there's no one there to pony it up for. These are the things that you need to consider when you're out there in the free world, because you were in the free world just now and you picked up a theft case. But you need to start thinking, well, even if I pick up a case where it's $100 to get out, I have no one that's going to get me out. Why? Why would we continue to, tell me.
And Your Honor, I mean, as the state mentioned, he hasn't forfeited any of his cases before, although he does have other cases. There's a few that you mentioned that were dismissed ultimately. And he has already provided me